Hi, my name is David, San Diego-based criminal defense attorney, and today I'd like to discuss with you the crime of spousal battery. Generally speaking, misdemeanor domestic violence is what a lot of people think of when they say spousal battery or simple battery in a domestic violence context. And that's usually prosecuted under Penal Code Section 243, parentheses, E as in Edward, parentheses, number 1. Once in a while, you also see the 273.5 version of the Penal Code prosecuted as misdemeanor, more serious domestic violence. Generally speaking, in order for someone to be convicted or even charged with a domestic violence battery, in some semblance of a relationship, familial, romantic, or otherwise, with the alleged victim. And then that there was any type of unwanted touching. Now, unwanted touching is the simple definition of battery. It could be, shoving. It could be flicking them with your finger. It could be, I've represented people where they were charged with spousal battery for pouring a bowl of soup over their husband's head. I mean, it's absurd the amount of things that could fall into the umbrella of spousal battery. And in all honesty, it's absurd the amount of things that prosecutors sometimes, particularly in California, may charge as spousal battery, whereas in other states or other municipalities, they would look at it and say, you got to be kidding me. We're not going to prosecute it. But the main reason a lot of times why these cases are brought to court and filed on is because if you're convicted of any domestic related offense, even something as simple as a misdemeanor spousal battery, the law requires that if you get probation, means if you don't get jail for a significant amount of time, and you're placed on probation for a period of anywhere, realistically, around 3 years, you will need to complete a 52-week domestic violence program. So, that's the biggest issue that a lot of people want to avoid, and I get a lot of calls about that. Hey, how do I get out of this program? I'll take a deal. I just don't want to do the program. Well, it's easier said than done because a lot of times the prosecutor will only offer a deal that encompasses the mandatory provision for these 52 weeks programs. So, there's a lot on the line as it relates to these cases. These cases are also priorable. Even a simple misdemeanor battery, domestic violence battery, can turn into a felony if there's another one within 7 years. So the consequences are great, far beyond a protective order, far beyond 52 weeks of domestic violence classes. So it's essential you arm yourself with the right attorney who's experienced and knows what they're doing when defending against cases of spousal battery.